If you visited a government website over the past several weeks, you've seen the messages that the radical left has shut down the government, or the Democrats have shut down the government. You've seen it on government websites of nonpartisan agencies, or agencies that should be nonpartisan, like Housing and Urban Development, or the U.S. Department of Agriculture, the USDA, or even the Department of Justice, the top law enforcement agency in the United States, seemingly violating the Hatch Act, a law that forbids partisan messages from government websites and government employees, all with highly partisan, highly inflammatory messages against the opposing party. And that's what Donald Trump is doing as leverage against the Democratic Party during the government shutdown. And he's also using SNAP benefits for food assistance for the poor and the hungry as leverage against the Democrats. And just recently, right before the recording of this video, it looks like a large enough contingent of Democratic lawmakers and senators have folded to the demands and bullying of the Trump administration. And they did that right on the cusp of two court victories against the Trump administration that would have removed that leverage from him. I'm going to break down those two cases today on All Rise News here on Legal AF, part of the Midas Touch Network. Take a moment to hit subscribe before we go into those rulings. The first of those rulings was about a case involving a major union for government employees, the American Federation of Government Employees versus the U.S. Department of Education. And that was a case about the government using the email accounts of furloughed workers as billboards, as a cudgel against Democrats, saying that the shutdown was caused by the radical left, caused by the Democrats, regardless of whether the employees actually believe that to be true, using the workers' email addresses to send those messages. And a federal judge, U.S. District Judge Christopher Cooper, found that illegal. And here's how he described what was going on in his ruling. He wrote, quote, "The new auto reply, standardized for all furloughed employees, states that the lapse in appropriations was caused by Democrat senators who are blocking the passage of a clean continuing resolution." End quote. Now, the AFGE, that union, fought back. And Judge Cooper found in their favor, found that the government had violated the First Amendment rights of workers who shouldn't be compelled to spread the message, shouldn't be turned into a billboard or a ventriloquist doll for the government's message and the government's agenda. Here's what his ruling said. Quote, "Nonpartisanship is the bedrock of the federal civil service. It ensures that career government employees serve the public, not the politicians. But by commandeering its employees' email accounts to broadcast partisan political messages, the department chisels away at that foundation. Political officials are free to blame whoever they wish for the shutdown, but they cannot use rank-and-file civil servants as their unwilling spokespeople. The First Amendment stands in their way. The department's conduct, therefore, must cease." Now, in every case when you're asking a federal judge to take some action, there's a balancing of the equities. You have to prove that you are being harmed and that the party that you're suing wouldn't be, if it is the government, that the government isn't being harmed and that that balance is in your favor. And in this case, Judge Cooper found it wasn't even close. He wrote, quote, "The government has failed to identify, let alone substantiate, any legitimate interest whatsoever in using its rank-and-file employees' email accounts to promulgate partisan political statements. If anything, the government should be concerned with preventing its employees with conveying political messages." End quote. And of course that's the case. That's why Congress passed the Hatch Act. That's why under no previous government has the party in power used the shutdown to turn every government website into a propaganda organ against the party that's out of power. That's not something that's very recognizable in the United States or any advanced democracy. That's not what the government and government websites are supposed to look like. Now, this was a First Amendment case, and the First Amendment protects, of course, your freedom of speech, but it also protects you from having the government compel you to speak something, particularly something that you don't believe, that doesn't represent you. That's at the core of free speech. Judge Cooper, here's how he put it, quote, "When government employees enter public service, they do not sign away their First Amendment rights, and they certainly do not sign up to be a billboard for any given administration's partisan political views." And just as the news broke that the shutdown was appearing like it is ending, that the Democratic senators, 8 of them, had reached a deal that would have ended this, and that they were going to essentially surrender without any meaningful concessions, a promised vote down the road that will pretty much be ceremonial. When that happened, almost exactly at that time, there was a major development in the case of Donald Trump's effort to suspend SNAP benefits for 42 million poor and hungry people in the United States, 1 in 8 people in the United States, including millions of children. And that development was the First Circuit Court of Appeals ruled against the Trump administration, saying they cannot suspend SNAP benefits. They would not pause the lower court's order forcing Trump and his Department of Agriculture to fully fund the state's SNAP benefits through the month of November. Now, it wouldn't be the end of the road. There's still the Supreme Court to contend with, and I'll get into that a little bit later. But here's what they found, because the contents of their ruling show the magnitude of the problem. The 3-judge panel wrote, quote, "The harm from a stay would have been immense. The government understandably makes no attempt to argue otherwise." And in the ruling, they go into some of the sworn declarations that they've received from some of the people who are affected by the suspensions. And some of them are heartbreaking, frankly. I'm going to read some of the ones that they listed in the ruling, the sworn declarations that helped lead to this decision. They wrote, quote, "The declarations describe a pregnant mother in Georgia forced to skip meals to feed her son, a working grandfather in Massachusetts who would eat twice instead of 3 times a day to feed his family, a mother in North Carolina who worries about how feeding her 3 children less will affect their health, and a nonprofit leader in Rhode Island whose clients will be forced to choose whether to heat or eat as the holidays approach, and winter bears down on New England. These immediate, predictable, and unchallenged harms facing 42 million Americans who rely on SNAP benefits, including 14 million children, weighs heavily against a stay." And it bears repeating that the lower court judge, Judge McConnell, found that this was essentially a political gambit, that the government knew and the government admitted that it had to spend contingency funds designated by Congress to keep SNAP benefits fully funded, that government lawyers essentially admitted as much in court, and that all of this pain and all of this turmoil suffered by these families was entirely preventable. The ruling says, quote, "As the district court found, this was a problem that could have been avoided. The record here shows that the government sat on its hands for nearly a month, unprepared to make partial payments while people who rely on SNAP received no benefits. A week into November, and counting. We'll find out very soon whether all of this, these two rulings, are essentially a moot point, whether the shutdown ends and the fact that Donald Trump has been using SNAP benefits as leverage, has been using his control over government websites and government messaging as a cudgel against the Democratic Party. Even as, from the results of the previous election last week, that it seems that people are seeing through that. But those two perceived points of leverage from Donald Trump, that he was using his control over government messaging, his perceived control over food stamps, were going to be negated by the fact that courts were pushing back. You've been watching All Rise News. To find out more about my reporting, visit www.allrisenews.com. That's www.allrisenews.com. If you want to support the work that I do, become a subscriber. It's a free subscription. And if you want to make sure that I can keep diving deep into the rulings, providing the key context, quotes, and information for you, consider becoming a paid subscriber. And to watch other videos like these for free, click subscribe now to Legal AF, and I'll see you on the next video.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.